Hello, namaskar to all of you. Today I will be discussing about the Right to Information Act of 2005 as given by Parliament of India. So, first to understand that right to information, so we have to go to statement and object of why this act was enacted. So, this is an act to provide for setting up the practical regime of right to information. So practical regime, we want to say that within the public authority, there will be something called first appellate authority. There will be central public information officer or the subdivisional level, or there are other offices, so there are deemed public information officers. So that this act sets off a practical regime of working for citizens. So exclusively, this is for citizen. The person uh, cannot file the RTI application if he is not citizen. To secure access to information, so there will be definition of the information coming later on in the definitions clause. So information, okay, under the control of public authority. So there is a definition of the public authority also. That means every authority is not public authority. So the right to information cannot be filed to the bodies which are not public authorities under that. And in order to promote transparency, the objective of the Right to Information Act enactment is to promote the transparency. What is transparency? Which is an anti of the opaqueness, that means clarity in the transparent manner. And accountability mean because India is the democracy. So in democracy there is something called rule of law, and in rule of law also there is a what is called accountability is fixed. Like people toward the public at large, every public officer has accountability. So that accountability this act want to promote in the working of every public authority. Working means their public function during the public function of the authority. The constitution of the Central Information Commission, as like Central Information Commission or Commissioner's Office, is statutory. It is not constitutional. It is not created by the Constitution of India. It is created by the Right to Information Act. So, in the RTI Act only, the provision of creation of the Central Information Commission is there. So, also, then the State Information Commission similarly are constituted under this RTI Act and matter connected. So for all other connected matter, this act was given by. So very like in good way, the acts like gives says that, and whereas democracy required the informed citizenry, that means citizenry has to be informed. If this information is not there, which is a part of Article 19(1)(a) also, like if there is no information, there is no media coverage or uh, public domain. If the information is not available, one cannot have opinion which is sound. That means for forming of the opinion, which is fundamental right under Article 19 only, also informed citizenry. For informed citizenry also, information is needed. Okay, and transparency of information, which are vital of the functioning of the public authorities, and also what they said, corruption. We want to contain the corruption. Like we know there are also to hold government and its instrumentality. The words are same. Like Article 12, state is there. So state and its instrumentality mean other authorities. Same way they said public authorities are also defined here. Like state government gives fund, central government gives funds, local authorities are created, or they substantially funding those kind of any organization which can become public authority. Under the act they have to give information. So we want to contain corruption and promote transparency in working of those government institution. You know, and then they have to, if state has to function, state has to give its secrets also. Everything cannot be given as a right to information. So there has to be some act which is kind of balancing the both conflicting interests, not conflicting, actually balancing. They are giving access to the citizen also, and also withholding the information which are vital for the functioning, like defense matter and other matter. Okay. So uh, because preservation of the confidentiality also is needed of the sensitive information, otherwise government cannot run. So this act was enacted, and it is very important to harmonize these conflicting interests. I mean, state's interest of protecting confidentiality is also needed to respect, and also citizens interest to have access to information for empowerment is also need to be balanced. So we will harmonize. In order to harmonize, this act was created, and preserving the paramount is semen learning high ideal of the democratic values, and this act was enacted, and certain informations are needed to be furnished to the citizen. That's why this act was enacted, to give in detail what is the information is the citizen deserves to have. Okay, the important definition part will go that I said, because in every public authority there will be central public information officer who will be providing information. If no designation is there, they have to designate. If there are like within the department also subdivisions are there and information relates to that subdivision, so there will be deemed PIOs. So this law is very clear. Chief Information Commissioner will be there, and the other information commissioners are there in Central Information Commission and also in State Information Commission. That is also given under this act. So some of the important thing, like in section 2F of the RTI Act, information has been defined. What is information? I mean any material in any form. Like example, including the records, documents. You will go to Evidence Act, documents has been defined. What is document? Graphical representative or word or graph. You can like express that. That is document, or any memos like memorandums, any like emails. Now we are talking about electronic under the Information Technology Act. Some of the electronic mails, emails has that informations. So that is also information. Opinions. During the function of the public authority or the government, some of the opinions are created, some of the advices are tendered, some of the press releases are getting old. In the public domain, it has been sent. So that is also information. Some of the government department, they issue some of the circulars. They are order for their employee and the general public. There are certain kind of registers are made, which are called logbooks, which can be like some of in the police station there are some registers. In the office you go attendance register, other registers are there. Some of the contract or the agreements signed between the parties, like here party is public authority, MOUs they will say, memorandum of understandings they are signing with the authorities. So that is also part of that information. Reports are there. Certain reports are there, like mm, the person wants to give certain kind of like commissions are constituted under some act. There are term of reference of the commissions, and they have submitted some of the reports. So these reports can be Law Commission of India report and other reports. To give example, these report also can be information. So other things are like there are papers, there are some of the samples, the models, data material. So in this 2F in detail they have given, which can be accessed by the public authority. That public authority should have access to them. That is also very important. Under any other law complying with laws will be called as information. Okay, what is public authority? As I said, that every authority will not give you information under RTI Act. So it has to be public authority first. So what is a public authority? It can be any authority, body or institution of self-government. They can be self-governing. So established or constituted by the Constitution of India, like Election Commission of India, Union Public Service Commission. These all are constituted by the Constitution of India, like Office of the Controller and Editor General of India, CAG office. So these all are created by the Constitution. So these are the public authorities. What all public authority, like any other law made by Parliament, like some of the Act of Parliament are creating, like some universities are created under Act of Parliament. So they will be public authority, and any other law made by state legislature. So in exercise of the, because there are three lists in the Constitution. So union list, concurrent list, and state list. And also international treaty also we are signing. So some of the authorities are creating. So it can be Parliament created or state legislature created authority. By that virtue of created by that legislature and the Parliament, it will become public authority. Or by notification issue also, government can issue notification saying that these authority from now onward is the public authority under RTI Act. So that will also become public authority. And it includes which all kind of thing, like which is the body owned, controlled, and financed by the government substantially, and the big way. Or NGOs also who are substantially financed and getting fund from where, and also directly or indirectly fund provided by the government they can. And there are something called records. What is record? So clause one of say, okay, you will go further to I. Section 2, clause I will tell you about the record. Any document is record, manuscript is there, or file is also record. Any microfilm, these all are electronic aspect. And also people will say, I have right to information. That also under section 2J is defined what is your right to information means right to information accessible under the Act, which has been under control of public authority. The control has to be there, and which includes what? Inspection of the work, documents, records of the public authority, and also taking certified sample of the materials. Like some materials is there, under that you can take a copy of that samples. No? And uh, uh, importantly we'll go provision. Then there is something called chapter 2 of the RTI, which say right to information and what is the obligation. So the act says itself, subject to the provision of this act, all citizens shall have right to information act. That means there is no other law regulating actually the the condition of controlling the right to information is given under the RTI. So it is subject to this act only. Every citizen has a right to information. So what is the public obligation of the public authority? Section 4 clearly has given that it will maintain all the records, publish with those records. And the particular of organization, you might have seen any public authority, you might have seen they have given how many people are working under there, what is the pay scale, what is the level of like their which level of the pay they are actually receiving, and what is their contractual tenure, everything they will be giving. and and decisions are made. So what is the procedure? They have to clearly tell, like there are certain organizational structure they have to tell, like what is the organizational structure they are working. Like if you go to any police department, so they will tell there is a commissioner of police. Under that there are certain special commissioner of police. Under that there are additional commissioner of police, a joint commissioner of police, and there are certain other functionary like DCP, ACP, and under that in police station also there are line of command, like from the SHO to the level of constable also there are line of command. So they can give those details actually. If the public resources also, like resources are sufficient to publish another thing also, the particular of. So I will not read everything. So this is given in the RTI Act for say, for the like benefit. I will go to the important section only. So section 6 says about request for obtaining information. Whenever you are requesting to the public authority for any information, so you will use the section 6 of the RTI Act, which says that a person who desire to obtain, the person I want to say is not, it is citizen actually. Only the citizen has access to information. So citizen who desire to obtain any information under this act shall make a request in writing. This is the same, like they have given under other acts also. And now electronic means is available. So online also they can give this RTI request, English or Hindi or the official language of the area. So so that is given. Okay, the CPIO or the SPIO. Of the concerned public authority. So there will be Central Public Information Officer, Public Information Officer appointed in the public authority which is defined under the Act. Then they can, to them we have to make application in writing. We have to address them. So If there are, as I said, there are subdivisions, small offices are there, the whoever is in charge will be deemed as a PIO. So there is a section 6 clause 3, then transfer of RTI also. If you are making to the main CPIO, then it is their further duty to transfer the same and give intimation uh, within the reasonable period of 5 days. Dark research to the informant that they are like RTI request has been transferred to those concerned officer and they can directly follow. So this is one. Then the 6 clause 2 says that an applicant making a request of information shall not be required to any give any reason for requesting the information, and also some of the personal details like your mobile number and other thing or are not needed if and this has no relevance actually, because if you feel that as a citizen it can be used for harassment, so you need not to give. Also, you should not state the reason why what use you will do after reaching this dark or the information to your hand. That is also you're not required to give actually. So also, so where an application is made to public authorities, so third I told the transfer of RTI application is also there, the provision. So section 7 talks about disposal of the request subject to the provision this, and they'll say that 30 days. In common parlance, we can say within the 30 days they have to give it. Okay, that provided that where the information sought for the concern of life and liberty, there is a 48 hour. Within the 48 hour, if the receipt itself is not giving, so that will count 48-hour life and liberty cases. If the CPIO SPIO fails to give decision to request, then what will happen? Then it will be deemed that they have refused the request under life and liberty clause. So 48 hour, the clock will start ticking. Then one can go to the first appellate authority and to the Central Information Commission also as way of complaint. So in coming sections, we will be going what is the process of complaints to be filed in the Central Information Commission or the State Information Commission for that case. Okay, so and so there are certain exemption clause very important. Section 8 exemptions are there. As I said that RTI the information has to be given to the citizen, but the exception will be containing an RTI act only. Then only these exceptions are valid as public authority can take. That has to be written in RTI act itself. So which are there? There shall be no obligation to give the information to the citizen when information disclosure of which would prejudicially affect the sovereignty integrity of India. So that is understood. Any security reasons are there, strategic reasons are there, scientific reasons are there, economic interest of the states will suffer by giving that, or there are good relation between the foreign powers. By giving that information, the relations are going spoiled. The state can withhold it, and some of the offense can happen if such information given. So it is justified from the Central Public Information Officer to not to give information. He had to justify just under Section 8. And there is a information which is forbidden by law. So there are certain laws, or the court has not given any kind of permission to give or supply that information. So these cannot be given. Any tribunal or disclosure of which may constitute contempt of court, I said, because High Court and Supreme Court, Honorable High Court and Honorable Supreme Court of India are the court of records. So they have power to punish for their contempt of which Parliament has given contempt of court act. So under that contempt provision, if some information is there and giving to that there is a specific direction of the honorable court that not to supply that, and and supplying of which can become contempt of court. So that should not be like that, cannot be given under the RTI Act. So there is a valid ground given under RTI Act. While framing this RTI Act, our legislature has kept in that thing. So another provision information which is like information breach of privilege of parliament and state legislature. So many times Parliament of India or the state legislatures are sitting and deliberating on issues, and there is a if the information goes to the informant, it will breach on their power. So that is if that is happening, so this is prohibited from supply. Okay, so information including some commercial competences are there, trade secrets are there, or intellectual property of the peoples are involved in that. So that means third parties will suffer a loss if, as a registrar of company or other authorities, you have received these informations or the patent right office, you have received those information, you should not disclose to third party on the RTI request, because the third party will suffer. So we don't want third party to suffer actually. So RTI Act has kept that thing in the mind. Okay. So another provision, but we are just referring the important thing. So fiduciary relations are also there. In good faith, competent authority has power to give that information also which they have received in good faith. If they said that larger public interest is there, so it will be subjective, and also we have to see in detail whether the public interest is there or not. What is the public interest? So the larger question has to be considered. And information from the foreign government is some of the information are endangering the life of the personal safety of the other person, or who has given information, that kind of details if given. So or prosecution of offender, that kind of informations are given in the RTI Act, so it will affect some of the party. So that is prohibited. And also cabinet paper including their record of deliberation, other things. So there are many right exceptions are given under section 8. So authority has to can only use those given enumerated in the RTI Act for denying the information, because informed citizenry we have to create. And also ground of rejections are given under section 9. That said that CPIO or the SPIO may reject a request information when the copyright infringement uh, is possible. Also, Section 10 is more enabling to the like PIO, CPIO, or the First Appellate Authority or the Central Information Commission to direct. So, and severity clause is there. Like out of 10 things, if seven I cannot give, the citizen has asked, but three I can give under RTI Act. There is no prohibition from any of the Section 8 exemption, it is not falling. So three I can give. That means severity clause is there. So whatever is not permissible, I'll not give. I'll give the justification as a PIO why I'm not supplying. If citizen can further go and appeal and other thing, and that is permissible. But whatever is accessible, it has to be given. And wherever the access is granted to the, then what will happen? Applicant has to be given detailed explanation. So that provision one has to understand. And there are like section 12 creates the office of the Central Information Commission. So we know there has been amendment to the RTI Act also. Some of the powers of the CICs are amended now through proper amendment. So, but for purpose of selecting, appointing the CIC, so they have given there will be one Chief Information Commissioner for India, and the State Information Commission will have CIC, also Chief Information Commission in that state. Okay, and such number of CIC not exceeding 10 for the Central Information Commission. So section 10 talks about Central Information Commission only. It is not talking about the State Information Commission. So there will be committee constituted to elect CICs. And so there will be selection panel. So the President of India, on the recommendation of the committee of the Prime Minister, uh, leader of opposition in Lok Sabha, and the Union Cabinet Minister, which is appointed by the Honorable Prime Minister. They three people, like esteemed personalities will be actually deciding on who will be chief information commission and commissioner and the information commissioner out of the select committee deliberations. So, so there are terms of office. I will not go because it's more of citizen empowering. So we'll go directly to the provision which are like under section 18, with chapter 5 of the RTI says power and function of the information commission, what is the appeal and penalty. So you have to understand that I said no practical regime. They have said what is the regime. So there is a central public information officer, there are state information officer, there are first appellate authority within the public authority. Then if you go out of public authority, there is a second appeal or the complaint in the Central Information Commission or the State Information Commission. So we have to understand whole framework first. So what is the power of the commission? So commission means subject to provision of this act. So RTI will act only will limit that. It shall be duty of the CIC or the SIC to receive inquiry or complaint of any person. That means one who is unable to submit a request to the CPI. Okay, a reason can be anything. Okay, who has been refused access to information, who has not given a request, and in the request there is no response actually from the public authority side, who believes that he was given incomplete, misleading, or the any the records whatever access was given it was incomplete or misleading. So okay, so that then the power of the CIC or the SICs are there. So they have a power as given under CPC, Civil Procedure Code of 1908. Actually, the Honorable CIC can summon and enforce attendance of the people. They can require and discovery inspection of documents, and they can request the public record or the copy somewhere in the courtroom or other thing. Also they can have access to that. They can also summon some of the witness or the documents for adjudication, we can say, or the deciding their appeals or the complaints given to the CIC, SIC. So that is there. Section 18 is more about power and function. Section 19 talks about appeal. So you understand their second appeal is there. Okay. So before that, second appeal always lie into the with the Central Information Commission or the State Information Commission. But before that, in the public authority, there is called Office of the First Appellate Authority, FXLA. So who has 45 days and time to adjudicate that first appeal, which is like against the Central Public Information Officer not giving access to her many issues. So in appeal, clause 1 says any person who does not receive a decision within the time specified, 30 days, or they have aggrieved from this CPI was then within 30 days. So there is a limitation period. Within 30 days from the expiry of certain period, these things they can file the appeal to senior rank officer of the CPIO, SPIO. As I said, who are these people? These are first appellate authority. They can drain, and they have given said that if the person was prevented from filing within the time, so he will be excused from that time limit. So where an appeal is preferred against order, then what will happen? Then under section 11 to disclose third party information. So many of the parties, like all the public interest group, can become third party with the permission. So then what will happen? Then a reasonable opportunity has to be given to them. Appeal. So will be not going into detail of that appeal provision, because I said it is very clear at the level of first appellate authority and the Central Information Commission or the State Information Commission, this appeal will lie. And there is section 20 penalties chapter, very important. Then now CIC, SIC, in the time of deciding any complaint or appeal, I said one, the complaint can come to it or the appeal can come to it. So they have a power of taking disciplinary action, or um, imposing certain penalties. They have also power to like recommend some of the actions. So some of the amendments are there, so it has to be updated, and the readers are advised to refer to the latest amendment of the act, not to get confused with the older. So that is also suggested that clarity in the law is needed, and so that is RTI Act for you. So the rest of the provisions are more of rules. Okay, how you will apply. So in a piece of paper, there is a sample of the RTI application. If you draft that now, because e version is also there, if you draft that and Indian postal order or the demand draft, uh, or the whatever like new base of online payment, also many authorities are coming with. If that prescribed fees is paid, and while sending that right to information act application by the citizen, so they can refer that to central public information officer, or then there are, as I said, that center assistant public information officers are there, also relevant authority send your RTI request sample you can use. After sending, remember to take one copy. Whatever you are sending, you should have record to that, so that tomorrow, if within the time you are not receiving the reply, then what can happen? You can file the complaint to the Central Information Commission or State Information Commission. Whatever suggested is to go by routes, like go to Central Public Information Officer, ask for the information. If information is denied, you go to First Appellate Authority within the time frame, and if the First Appellate Authority is giving access after consideration of everything, like public interest, RTI Act, other acts requirement, courts, everything, balancing every interest. He has a right to overview that if revision also is not able to fetch you the information is needed for you, so then you can think of uh, filing appeals, second appeal to the Honorable Central Information Commission or the State Information Commission, whatever the case may be. So you can file to them. You have to wait for listing. Some the listing can happen. So now there are provision of the National Information Center NIC studios are used by the Honorable CICs and the SICs to conduct some of the video conferencing also. So if you cannot attend in time, you have to inform the Honorable Commission that they can arrange through the NIC studio of that hearings, so that your right to information is also protected. Also, whatever is denied, then there are certain like um, institutional reforms in the CIC, SICs are also needed. Like there are also state responsibility to not to like make the institutions of the CIC, SIC weaker. So it has to be deliberated in detail, like autonomy versus independence. So there are many issues. Autonomy and the independence of the institution has to be kept. Also, if there are some confusions, so that also has to be clear. So I will like to hear more from you, because it's more of legal framework of Right to Information Act, which now amendment also has affected. So I want to create some kind of awareness regarding the issue. Also, I want to learn the difficulties common citizenry has while exercising those kind of rights. So some of the like feedbacks are needed, helps are needed, so that peoples are actually exercising that right of information. Also, informed citizenries are created, and public authorities also has to be become proactive, because forcing the citizen to file RTI and not declaring many things in the public domain, it will go against the ideal of the democracy. So if one has to like strengthen the democracy, then they have to strive to be more transparent in their working, and also uh, getting some of the feedback from the civil societies and other people who are equally interested to have access to that information, which are very important, like some of the public recruitment and other thing, it become very important because there are Article 14 of the Constitution which says equality of opportunity, which is like as along with equal protection of law, there is equality before law. If there is no publication of those information in the public domain, how many people are participating in that interview or the selection job interview exams, if in the public authority, if the result, the people selected, the list is not declared in public domain, the per se merit also is not declared, everything is done under the veil of secrecy, then we are ultimately defeating the Right to Information Act, which the Parliament of India wanted to give to citizen. But so that introspection has to be there, so that our each action has to be for public welfare, and know how public welfare will happen when the public will know in detail. Actually, if I am the applicant, so I should know where actually I am placed in the merit list, what went wrong actually, which are the areas I have to improve, and where exactly the need. So, in that way, the administration has to take, or the public authority has to take the right to information request also in proper spirit, and the people can also work for not harassing the public authority for right to information request. They have to use, not misuse the provision. So, if there is right to information act, so one has to use it wisely. Mm. Also, if there is genuine requests are coming from citizen side, so public authority also has to give the informations replies, so that person is not forced to go to public first appellate authority, second appeal, wait for the hearing for the many years. So this all frustrates the like objective of enacting right to information. So with that belief, and also with the aim of strengthening some of the citizenry who are like genuinely wants some clarity on the concepts, I will be like very happy to receive in comment section some of the valuable suggestions how actually the citizen-centered representation can happen. Also to highlight on many changes of law that is happening. So through mutual discussion only we can create. So with that hope, I am creating this video. So some of other legislation I will be discussing. So readers are suggested to refer also to the latest amendment of the RTI Act. So that will more create the like exact literacy among people, and they will know. So with that hope, I say this attempt is to empower us.